paper and a pen or pencil because you get to write. We are going to move right along. Some things to keep in mind on the SCOTUS comparison FRQ. This one's a bit of a challenge, but a fun challenge. So it's weird because you're going to have 3 tasks put in front of you, but you have 4 points. So the A point is going to ask you to identify, sometimes describe, but usually identify a constitutional concept or clause or a judicial doctrine as indicated. Our second point is usually going to ask you to say something true about the required information from your required case, which could be fact, decision, reasoning, majority opinion, and then to compare it or to contrast it with the case in the scenario. And that's our second point. So our C point is then going to connect back to some course concept as it intersects with the case in question. So again, we're looking at describing facts, reasoning, decision of majority opinion, comparing those reasonings, facts, and decisions, and explaining how or why they apply in context. Something else to keep in mind is that there are 4 discrete things that you need to pull down from every single case that you are required to know. The first thing is you need to understand that there is a majority decision, and that's really where we're narrowing our gaze. The majority decision is going to be written by a justice, and it's going to be the prevailing interpretation of whatever is at question before whatever issue is before the court. You are also going to be asked to know facts of the case, and the facts are usually going to be found in the syllabus. I always tell my students to go to websites like Justia or the Supreme Court's own repository of cases and actually look at the cases as they've been published by the Supreme Court. Because in the syllabus, which is usually written by staffers within the Supreme Court, they're going to give you the facts, the whole thing, and the reasoning. And it's a little bit easier, and it also is a little more accurate for you to collect that information for use on the SCOTUS FRQ. So the facts of the case have to do with what the government did in the scenario, they passed the law, so on and so forth, and then what are the events that happened that resulted in this case going before the court, whether it be a criminal case or a civil case. The next thing you need to know is the holding, and that's the outcome. It's usually going to say something along the lines of this action by the government is constitutional or unconstitutional on the basis of this part of the Constitution or this statute, whatever it might be, but it's that outcome, and it answers the question given this set of facts in this law, this is the outcome. And our reasoning is the whole point of the opinion. That's what most of the time is spent doing. That's providing reasoning and rationale using precedent, facts, history, ethics, application, all of those things that help the justices arrive at their holding. So we use those terms, and any one of those terms can be points of comparison. Be prepared. If it says facts of the case, that's a very different thing from holding and reasoning. All right, so let's take a look at this. Remember, you're probably not going to be aware of the case that you have to compare it against. Maybe you would be, maybe you wouldn't be, and that's perfectly fine. You have enough information in front of you to answer the question. So this is Tyson Timms, a 2013 case that was handed down. There was the application or the interpretation of this amendment was handed down in 2019. So take a screenshot, read through it, and then we're going to talk some questions. All right, let's take a look at our A point. Now, our A point is going to be an identify, which is just naming something, and that's our favorite task verb because it is the easiest thing for us to do. So identifying the legal doctrine. Now, this isn't going to be, a legal doctrine isn't the same thing as an amendment or a right or a clause in the Constitution. It is something that the courts have created that is kept in line through precedent. And so that's very different. It's not going to be a good time for you to say, oh, the First Amendment or the 14th Amendment or the 9th Amendment. Here in our answer, we are looking for that legal doctrine, and I always tell my students to repeat that prompt. So that we know that they're answering the question that's been asked, right? Here is our answer, a good example of how to earn that point. The legal doctrine that is common to both Timms versus Indiana and McDonald versus Chicago is selective incorporation. So they're going to go on, and I'm going to tell you that all the other stuff, supremacy clause, and the given definition of what it is not necessary. Even selective incorporation, they're kind of showing us the impact that it's building off of it, and that cases incorporate federal laws, protections, and rights. That's more of a definition, and that's one more step of intellectual rigor that we don't actually have to have, but it doesn't hurt to have. It would never hurt you. Because the answer is satisfied here. And that's selective incorporation. All right. So we have a B point, and this is our tough one. I'm going to go ahead and give you a moment to take a look at that B point and to pause the video, and let's see an example of a good answer. All right, so we're back. We want to explain the holding in McDonald's and compare it to the holding in Tim's. Now, good news for us is that these are relatively easy things to recall, right? What was the outcome? So what did they say in McDonald's? Well, we first have to say something true about the holding in McDonald's to earn our B1 point. And then we have to compare a true statement about the holding in Tim's. And they talk about the holding in this scenario for Tim's, so we just got to go back and be able to identify it and describe it. So here are the responses. In McDonald versus Chicago, the Supreme Court held that McDonald had the right to own a handgun under the Second Amendment, even though it was illegal. That is our answer right there, the holding, right? We are getting at that we're holding that it is totally perfectly fine. And we see here, I've highlighted for you that since we're comparing, I've also gone ahead and looked at, well, where is that comparison happening, right? And that comparison has to get at similarity. So we see hold, similar here down in this response, which are all indicating that we are showing the right direction in our answer, right? So what is that? Where did we get that? We said that the right to own a handgun under the Second Amendment is illegal in the city of Chicago, and that McDonald, his rights were violated by this law from the city of Chicago, right? That's the holding. So now we need to look at what is the holding in Tim's, that this law, this protection against excessive fines was a violation of the 8th Amendment, and they go on to add some reasoning, but it's just that this action by the state of Indiana was unconstitutional also. That's an adequate comparison. I love the last sentence where they come back around and they're going a little bit further to show that they see that line of similarity by saying both cases involve applying an amendment from the Bill of Rights to the states and striking down an action of law or state and local government. That's kind of coming full circle and showing I understand these are two different amendments, but they are both being applied to the states in the same way, and that's selective incorporation. So it's a very nice arc. We're going to do a non-example now, which is McDonald's case was on whether or not possession of firearms was legal in Chicago. There was a law that prevented the Second Amendment to hold. The court ruled that the law was unconstitutional and struck it down. That's making it selective incorporation. Holding and ruling are similar but not necessarily the same. So we really want to make sure that we have holding, like that outcome, right? That is unconstitutional. So we want to make sure that we're using language from the prompt. And the other thing I would say here is that this response does not get to the comparison with the holding in Tim's. So they would get a B1 point, mostly because they're saying this is the holding and it's something true about McDonald's, but they would miss that B2 point because there's no comparison. All right. So then we want to look at how this decision in Tim's affects the reserve powers of the state. So we need to make sure we know what the reserve powers are. I'll give you a little hint as you pause your camera and do some writing. All right, coming back around. Here we're going to say, this response goes on to say that states reserve the right to make their own laws and administer their justice system. That's actually giving us this reserve power definition, right? Which is a great place to start, is to define what the reserve powers are. The response goes on to say that the Timms decision limits the scope of what a state can legislate and enforce by applying federal law over state law through the process of selective incorporation. So we're addressing how selective incorporation changes, and in this case, limits the powers that are given to the states, right? And so again, that's a process, right? The process of selective incorporation, they spell out what it is. States are accountable to federal interpretation and Bill of Rights. And to be sure, they're going back to the Timms decision to say, okay, like what were we specifically limiting here? And it had to do with what was an appropriate punishment as defined by the federal courts. Well, there you go, my friends. We have gone through our first SCOTUS FRQ